Under the hearsay rules, a party's admission has a special status. Even if a party's admission statement otherwise qualifies as hearsay, the party's opponent may still present evidence of that statement. Do the hearsay rules allow the party himself to present that exact same evidence? The Wisconsin Supreme Court addressed this question in State v. Johnson. Gwyn Johnson started and was president of a corporation that employed construction workers. The corporation withheld taxes from its employees' paychecks and was supposed to pay them to the state, but the corporation never made the payments. Johnson was criminally charged with willfully failing to pay the state taxes. Johnson's defense was that his failure to pay wasn't willful. Johnson presented evidence that the corporation was heavily financed, and, as a result, a bank and a cosigner both had significant control over the corporation's finances. Johnson testified that although he'd wanted to make the tax payments, he didn't have enough control over the corporation's money to do so. At trial, the state called the corporation's accountant as a witness. On direct examination, the accountant testified that he'd had a conversation with Johnson in which Johnson had admitted to not paying the state taxes. On cross-examination, Johnson's attorney asked the accountant about the rest of that same conversation, but the trial court excluded the question on hearsay grounds. In response, Johnson made an offer of proof that if the question had been asked, the accountant would have testified that Johnson had said he was concerned about the unpaid taxes, but that he didn't control the money needed to make the payments. Johnson was convicted and sentenced to 6 months in jail with work release privileges and 2 years of probation. Johnson appealed to the Wisconsin Supreme Court.